objecting to the court conducting a proffer of any of the experts.
I figured that was coming.
So that's what those are about.
That's what they're about. Okay.
Probably 100. 802. 7 second. 442. And that's partner. This is regarding the original issue, the prejudicial discovery violation, not Judge, do you have Westlaw up there? I have one more case, but I don't have copies. Do you want me to have a part of it?
know my password.
Okay.
And I actually remembered it.
One more case on the prejudice issue also.
That's what I should look up.
If you guys, whenever you have a chance. It's 802 Southern 2nd 442 Portner, Portner, East State.
Okay. I haven't even read, you're waiting Mr. Jonchuck's presence, right?
Yes, ma'am.
I haven't even read these cases that Ms. Manuel gave to me, but I suspect that I have no business conducting a hearing with their experts inquiring as to what their opinion would be based on new evidence.
That's not what those cases stand for.
Okay, I didn't read it. Okay.
My understanding of those cases would stand for we can't necessarily, at best, the cases stand for we can't ask them when they learned of this, did they discuss it with their attorneys, that kind of thing. They're talking about attorney-client privilege and work product. But I don't see anything there will prevent the court from, does this change your opinion? How does it affect your opinion? The statements that were elicited by the witness, they can't create error. The issue and then rely on invited error and benefit from that invited error. The court is trying to at least restrictive means is my understanding, other than excluding the testimony. The only way to do that is they are claiming they have some kind of prejudice. They haven't shown it. They have to, if their witnesses are not going to change their opinion, then their witnesses can testify to that. If the court wants to keep out when they learned of that testimony, other than from the witness on the stand or just recently, that's a decision the court can make, but it doesn't change the fact that the court should be looking at the least restrictive means. We're still back, obviously, arguing that it's not even a discovery violation, but if it is, if the court finds that it is the technical one, then the court should not exclude this testimony, and their experts should be given the opportunity to review that evidence and make a finding on that evidence. This is not inquiring of attorney-client privilege. This is not work product. This is not any of those situations. This is new evidence in which they are allowed to review and make a decision on.
What do you say to that argument? I haven't read the cases yet, but it makes sense.
It doesn't make sense at all, Judge. We do not waive any confidentiality with an expert witness until we call that witness to the stand in trial.
I would agree with that.
Had we had that information, we may have never called any of those witnesses to the stand. Certainly, Otto and Mayer hadn't been called yet. Dr. Mackless was mid-testimony, but there's a real good argument that Dr. Mayer and Dr. Otto would have never even been called. We would have never waived that confidentiality. So to say now that because of the discovery violation, confidentiality was waived and now we can inquire of these people essentially what work product would be is improper. The proper route is, we obtain information, we make a strategic decision among the team whether we're going to provide that information to an expert. Then we have strategic discussions with the expert regarding that material. To say that we're going to just all go through that process together in open court violates Mr. Jonchuck's right to a fair trial. To say, okay, we're going to have these confidential communications with the state attorney present, with the court reporter present, with the judge asking questions of the witness.
I agree. I'm not going to do that. I'm not going to inquire of their experts, their change of opinion in a public forum as to this new piece of evidence. Mr. Ellis, I can't get around Ibera where the defendant's statement to the officer was used in impeachment, and obviously one could argue that the defense counsel may have known that, they may have not. However, the rule requiring discovery of the defendant's statements applies equally when the statement is used for impeachment purposes. The error is harmless only when the state can demonstrate beyond a reasonable doubt that the aggrieved party was not procedurally prejudiced by the violation. So to me, the burden falls on you. The Celestine case mainly addresses the fact that there never was a Richardson hearing, and there should have been. You can't really tell, because apparently there was some kind of motion to suppress here. There's no change on the fact that you're stating it today and have said it in your deposition, correct? The trial court found the statement had not been made as a result of interrogation. Okay, so nobody ever even argued that. And the case is from 1998 from the 5th District. So it was never really argued, and there's this little paragraph, and I agree with you that they said that although the statement didn't appear in the written reports, it is clear the defense was aware of the statement as evidence from the testimony of Corporal Ashley that he had disclosed this information in his earlier deposition. So I agree with you that this says what you're saying, that you can't claim a discovery violation if you were already aware of it. However, these other cases don't agree with that. I mean, Brown versus State, 4 DCA 165, Southern 3rd 726. I mean, they're kind of an unbelievable case in a way, but it says they knew about the videotape, they used it in the prior trial, this is the next case, and it was a discovery violation because the state didn't tell them they were going to use it, and clearly they knew about it. And I'm trying to find, there's one more, I think. Maybe not. So, I think it's a real problem. I wish it wasn't a problem. I think it's, I agree with you. I think the statement is a statement that is extremely important that the state put in front of the jury. But I also agree that the defense is highly prejudiced. It's a killer statement.
What about this argument, Judge? If we met with the witness on Monday and gave that information to them on Monday, like they're suggesting we should have done, I think they could still make the same argument that they're prejudiced, even though we just learned it in the middle of trial, because the jury had been sworn, the experts had been selected, the experts had already formulated their opinion prior to trial and given depositions in the case, so I think they could still make the same arguments even on Monday.
Yeah, maybe, but we're not on Monday. Maybe, I don't know. I don't think I can let it in. It's not because I don't want to let it in. Shouldn't say that, but I don't think pursuant to these recent cases, I can let it in. I mean, you would have to show me why they're not procedurally prejudiced. And I don't know how you can do that. And I think the other statements can come in. I stick by that. Because I don't think they're prejudicial. Those other phone calls.
Judge, you can't let, we'll complete this, you can't let some in and not, if it's a violation, it's a violation all of them.
Well, that would be your decision then. If you wanted to get in the other ones, I'd let you get into them. Because I don't think those other phone calls are prejudicial. And I think one could argue that they're beneficial to the defense. And another way to look at it, too, it doesn't really matter because their experts haven't testified about it, is that it's a further symptom of his mental illness. It could be argued that way. But it could certainly more strongly be argued the way you want it to be argued. And I don't think I can. I want to, but I don't think I can.
What about the fact that one of their experts knew about it, testified, and never mentioned it?
What difference does that make?
Is that a discovery violation on their part? And if so, could we call that expert to the stand and question them about it? They had this information, they relied on it, they
Well, I guess
reviewed
that's something that we could take up during the flow of the trial. I don't have to make that decision. The only decision I'm making is what Miss, whatever her name is, Malcolm, can testify to, not right now, but Monday morning.
Right, I understand. That may be something we may ask if you're on our rules that way, that we would be allowed to.
Well, I'm ruling now. I just don't know how other way I can rule. So that's how I'm ruling. Okay.
Obviously, we object to it, Judge.
I know.
They're inviting error. You created the situation, and when they created a situation, they want to now be able to benefit from the error that they created.
I don't think they created the error. I think it was an inadvertent slip up on your all's part. I don't think it was intentional, but I don't think they created it. They didn't do it. They didn't have an obligation to do anything, but you did. So, do you want to do this other motion? Defendant's motion to reconsider the court's ruling?
30 seconds.
To do it any other way would be, in my opinion, intellectually dishonest. And sometimes, hold on, you shouldn't try to see how you can do something to benefit one party or another, but I think we're all guilty of it sometimes. But there's no way, in my opinion.
And I still don't understand, Judge, how that information cannot be presented to their defense experts, and the defense experts make a decision on it. If they sat through the trial and it came up during the trial, they could watch witnesses as experts always do. They can make that decision. That's not going into attorney-client privilege. That's not going into work product. That's information, that newly found information that they can make a decision on. I don't see how that is prejudicial.
It is because the confidential experts,
They're not confidential.
the expert's opinion is not subject to cross until it's used, and they're not using this because they didn't think they were going to need to. There's no way that I would force the defense to put their people on the stand and say, okay, what about this? What do you think? I'm not going to do that. Okay, so are we hearing the other motion or not?
I need a second to redirect. I was researching all the other stuff and
Well, I
trying to
think
get
this is going to be pretty short. I'm not inclined to revisit this out.
Okay.
I think I made the right decision. So I'm going to deny that. Okay. So.
Can I just put some cases on the
Sure,
record?
sure.
Okay. Sorry, Judge.
That's okay, we got all afternoon. I don't think you have any remedy at this point. No, I'm talking to the state about the other discoveries.
So regarding...
Right, hold on a second.
I'm sorry.
I don't think you do.
Well, before when I was talking about calling the witness, I meant calling their witness to the stand, and I don't think I was clear about that.
Well, that's fine.
Okay.
You can do it that way.
That's what we'd like to do.
Yeah, I don't think there's anything that,
Well, I think there would still be the issue with Otto and Mayer because confidentiality was waived after the discovery violation occurred. So I think there's an argument that confidentiality may not have been waived. They would not have been necessarily put on the stand if we had been provided that information. And it would, it sounds like they would be calling to discuss work product because we are only required to disclose to the state information that we provide that our expert relies upon.
I think you would be allowed to ask if they knew of it. Are you aware of this?
It would be improper for the witness to answer that question because that would violate work product. That is a strategic decision, whether somebody was aware of it and it was not called. There's no way that does not get into the strategy of a team, whether somebody was aware of information and didn't say something about it or not. I mean, that's getting into the strategy. If they relied on that information, we have a discovery obligation that we are aware of and would comply with, most certainly, if we had an expert that relied on that information and their opinion was changed, or they relied on the information informing their opinion.
I understand, but what is wrong with the question, were you aware of this?
Because that gets into confidential communications.
But it doesn't.
It does, though.
How does it get into confidential communications? They're either
If they
gonna
say, and
yes or no.
if they were made aware of it before the state disclosed it,
Well, they never disclosed it.
right? So that's all.
Well, I don't have to decide that today, right?
No, you don't decide today.
Okay. And probably not even on Monday.
Probably not.
All right. So you can go ahead and put whatever you want on the record about the
Okay.
CLR.
Judge, we filed a motion for reconsideration regarding the court's ruling on the term psychopathy or psychopath in reference to the PCLR. I have provided the court and state with State v. DEMENIUK. That's at 888 Southern 2nd, 655, a 50 CA case from 2004. That discusses that Frye requires the judge to perform the function of gatekeeper, that the admissibility, the gate of admissibility is not opened unless the proponent of new scientific evidence can demonstrate by the greater weight of the evidence that the scientific principle upon which the evidence is based and the testing procedures used to apply the principle to the facts of the case have gained general acceptance for reliability among impartial and disinterested experts within the particular scientific community. According to Dr. Burston's testimony during the hearing, Dr. Lazaro's testimony during deposition, they did not, this is not pure opinion testimony. They both relied on the administration of the psychopathy checklist revised, which takes it out of the realm of pure opinion testimony. I think LeBron discusses that, where if you combine opinion and a instrument or some kind of testing or a database, then it makes it no longer pure opinion testimony. All of the research suggests, including the testimony of Dr. Otto during trial, Dr. Burston during the motion, that there is no research or anything to suggest that the PCLR is certainly not a preferred nor even a recommended instrument that should be used in determining mental state at the time of offense. The LeBron case, I'm sorry. In the Demunic case, the defense was, this is a first-degree murder. Defense has raised the issue of insanity. The defense sought to elicit testimony that the antidepressants the defendant was on caused the defendant to self-medicate to treat her depression, which caused her to ultimately be intoxicated and commit a murder. The state fought to exclude it. The court held, well, it's kind of confusing. It's kind of similar to what happened here. There was a hearing set, but only part of the hearing happened. Then at the hearing, the defense called one of their doctors testified for about 5 hours. When the state cross-examined the doctor concerning the studies he relied on in reaching his opinion regarding the effects of the antidepressants, the witness related that he based his opinion on 2 studies regarding premenstrual syndrome that were undertaken in 1992, 1993, and on a 3rd unpublished Scottish study regarding depression suffered by some women during premenstrual time periods. He agreed that he had not personally been engaged in the research trials of the drugs, but said that he used the results of that research in his clinical practice. Finally, he said that he also relied on a healthy volunteer study conducted by another doctor. That hearing was convened. The court came back and said, I'm going to allow that, and we don't need to have a Frye hearing because it's pure opinion testimony. The state filed a writ, and the appellate court said this is not pure opinion testimony. Once they have used these other things, it becomes then a Frye issue, and specifically they needed to conduct a Frye hearing because the witness, per the witness's own testimony, there was no studies to suggest that this was a thing, which is exactly what we have here. Dr. Burson's own testimony suggests that the PCLR is not recommended or suggested to be used in the determination of mental state at the time of offense evaluations, that there is no literature. He actually testified that would suggest that. Dr. Otto indicated the same. Also in LeBron v. State, that's at 232, Southern 3rd 942. That's a Florida Supreme Court case from 2017. In that case, the defendant was seeking to introduce a specific kind of brain scan into evidence. They, at the Frye hearing, the proponent of the evidence bears the burden of establishing by preponderance of evidence. At the Frye hearing, the doctor that the defense had wanted to call testified about peer-reviewed studies that used that specific scan having been used in comparing individuals to normative databases. He testified about the software used. He's been using it since 2005. He indicated that that is registered with the FDA and that registration establishes the appropriateness of the NeuroGuide analysis to be used by qualified medical or clinical professionals for the statistical evaluation of human EEG. He also indicated that there was a 400-page abstract he had reviewed with 795 peer-reviewed journal articles, and said that between 130 and 150 of those 795 articles supported his subfield about using that scan. He indicated that the weight of that evidence of the Frye hearing established the general acceptance. The Supreme Court said no, that didn't satisfy Frye. It says two other witnesses that testified at the hearing and stated the QEEG was not generally accepted as a means of diagnosing brain damage. He admitted that it was not proper to diagnose brain damage based on the QEEG data. Further, there was testimony that pictures produced were misleading because they colored large areas of the entire area. And so they ultimately said that this did not pass admissibility under Frye. Then just to cite Murray v. State, 838 Southern 2nd, 1073. That's Florida Supreme Court case from 2002. Fletcher v. State, 168 Southern 3rd, 186. That's Florida Supreme Court from 2015. That case discusses testimony that was admitted regarding the PCLR. Interesting, they say something. The defendant had called a mental health expert. This is in the penalty phase of a capital case. Called a mental health expert who testified. That expert testified that he had antisocial personality disorder. They said that Fletcher did not open the door to lack of remorse evidence by calling an expert who testified generally that he suffered from antisocial personality disorder. The court has repeatedly held that a diagnosis of antisocial personality disorder does not permit this type of testimony. Specifically, in Atwater, the court stated that a trial court errs in permitting the state on cross-examination to ask the defense expert whether the persons with antisocial personality showed remorse. In fact, this and so in our situation here, one of the characteristics in order for them to discuss and cross-examine the PCLR, remorselessness is an actual condition, and it said there was, they ultimately found that there was no reasonable possibility that the reference from that doctor's testimony, he improperly testified about the lack of remorse, but ultimately said that it wasn't, or that it was harmless error. But says, nevertheless, we caution the state to take precautions to prevent a reoccurrence of this problem that arises when a defendant permissibly offers a diagnosis of antisocial personality disorder as a mitigating circumstance. As we have stated, this type of evidence in itself does not open the door to the state rebutting the testimony with questions about lack of remorse as a feature of the disorder, and all of the things that are a feature of the disorder that they intend to introduce carry that same prejudicial effect. I also have provided Chavez v. State, 12 Southern 3rd, 199, Florida Supreme Court case from 2009. This is again going through the process that the court is required to entertain before admitting the expert testimony. This requires the court to make, it is within the court's discretion to determine the qualifications of a witness to express an expert opinion. This determination will not be reversed absent a clear showing. Before an expert may render an opinion, the witness must satisfy a four-pronged test of admissibility. The section requires the court to make two preliminary determinations. One, whether the subject matter will assist the trier of fact in understanding the evidence or in determining a disputed fact. And two, whether the witness is adequately qualified to express an opinion. Once those two threshold determinations are affirmatively satisfied, two more requirements must be satisfied for the admission of expert testimony. The expert opinion must apply to evidence presented during the hearing, and the danger of unfair prejudice must not substantially outweigh the probative value. And so in that case, for the expert to testify about the PCLR, it would be improper for them not to get into what that is. And there's no way for them to do that without then the prejudicial effect outweighing any minimal probative value. And then looking at Ramirez v. State, 810 Southern 2nd, 836. This is Florida Supreme Court case from 2001. This one is this is the case that came back like 4 times. They refused to have the Frye hearing. This is a tool mark identification evidence, and the state said, well, we've been doing tool mark identification for years. It's always passed Frye, and which is kind of the situation we have here. While the PCLR has been approved as passing Frye in future dangerousness or risk assessment, there is nothing to suggest that I have been able to find that the PCLR has passed Frye for the purposes of insanity at the time of offense or mental state at the time of offense. I haven't been provided anything from the state. If they have anything, I certainly haven't been provided it. I have looked for years now and have been unable to locate that. In this case, it was, so traditional knife mark evidence is a subgroup of the broad category of evidence commonly referred to as tool mark evidence. The underlying tool mark evidence, which is explained below, is generally accepted in the scientific community and has long been upheld by courts. However, this witness, it says Hart's theory, which was the witness that the state was calling to introduce in this case, Hart's theory of knife mark identification, however, departs from traditional knife mark identification theory in significant ways, and the state has cited no appellate decision upholding his theory. Which is what we have here. Yes, insanity evaluations have been going on for years, and PCLR evaluations have been going on for years. However, using the PCLR and testifying about somebody's mental state at the offense is not recognized in the field and in the expert field. The court ultimately had Hart's testing procedure is based on the premise that every knife blade is unique due to microscopic imperfections in the steel caused by the manufacturing process. These imperfections leave lines or striations when a knife is plunged into human cartilage. Because cartilage is relatively firm, it retains the marks. They go through the following technique that Hart implies. And it says, according to Hart, a technician's ability to identify the similarities in casts is developed by training and is passed on from one technician to another in the workplace. A match under this method is declared if there is sufficient similarity. This determination is entirely subjective. It's based on the technician's training and experience. There is no minimum number of matching striations or percentage of agreement or other objective criteria that are used in this method. No photographs are made of the cast, Hart explained, because laypersons No photographs are made of the casts, Hart explained, because laypersons and those not trained in this procedure will be unable to understand the comparison process. Similarly, no notes are made describing the basis for identification. Once a match is declared under his theory, no other knives are examined because an identification under this method reportedly eliminates all other knives in the world as possible sources. There is no objective criteria that must be met. There are no photographs, no comparisons of methodology to review, and the final deduction is in the eyes of the holder, i.e. the identification is a match because the witness says it is a match. They said during the hearing, they ultimately, the Supreme Court said that this fails the Frye test. It says, although several of the state's experts, I think the state ultimately called 3 experts or something during the hearing, although several of the state's experts testified that the underlying principle employed by Hart is generally accepted in the field, we conclude that this testimony, standing alone, is insufficient to establish admissibility under Frye in light of the fact that Hart's testing procedure possesses none of the hallmarks of acceptability that apply in the relevant scientific community to this type of evidence. This is particularly true in light of the extraordinary precise claims of identification that Hart makes under his testing procedure. And so they held that it was, after going back multiple times to actually have the Frye hearing, that did not pass Frye, and that's something as simple as tool mark identification, which certainly could pass Frye for other means. And then finally, Judge Williams v. State 779, Southern 2nd 314, second DCA case from 1999. In this case, the state sought to introduce an expert witness regarding battered spouse syndrome. This was a sex spat. The defendant, I think, was an ex-husband of the victim or estranged husband of the victim. The defense was consent. The state filed a notice of intent to introduce expert testimony that the victim lacked the ability to consent to sexual intercourse with the defendant because she suffered from battered spouse syndrome brought on by the previous beatings of Williams. The defense sought to exclude the evidence, indicating that it did not, the defense sought to exclude the evidence, and argued that battered spouse syndrome evidence is novel, has not been recognized as a mental defect, and recognized as passing Frye for the purpose of proving consent. The court ultimately agreed with that. They said yes, Barbara Stein ultimately testified over the defense objection that the victim suffered from post-traumatic stress syndrome caused by the defendant's prior beatings, and from battered spouse syndrome, which causes the victim to adjust her behavior to avoid abuse. Dr. Stein recited as the basis for her opinion numerous incidents of discord between the defendant and victim, described in detail the victim's history of being harassed, intimidated, and physically and emotionally battered by the defendant. Further testified that as a forensic psychiatrist, she uses techniques to detect whether a victim was exaggerating or lying. The defense objected several times during the testimony, moved for a mistrial, arguing that Stein was improperly vouching for the victim's credibility. They ultimately said her testimony, which lasted about 1 hour and 40 minutes, became the primary feature of the trial, and ultimately said that the court had erred in denying the defense motion in limine to exclude that testimony. They said, although Hickson holds that the battered spouse syndrome meets the Frye test and is admissible to support a defendant's claim of self-defense, we do not believe that Hickson stands for the proposition that such evidence passes the test for all purposes. They cite to Ramirez again that the Supreme Court has said the burden is on the proponent to prove the general acceptance of both the underlying scientific principle and the testing procedures used to apply that principle to the facts of the case at hand, and indicated that the state had to prove not only the general acceptance of battered spouse syndrome in the relevant scientific community, but also that the testing procedures used to show that a person diagnosed with battered spouse syndrome lacks the ability to consent to sexual relations with the batterer. We are aware of no scientific basis to support a conclusion that battered spouse syndrome robs a person of the ability to consent, and none has been presented to us to consider either. So they held that actually said we didn't even get to Frye because the testimony failed to pass the 4-step test, which, although I think in our situation we have plenty of evidence. In fact, the only evidence that has been elicited is, yes, I use this in forming my decision, but agreeing that it is not widely accepted in the scientific community to do so. Dr. Burston testified, we expect Dr. Burston and Dr. Lazaro to testify that certainly I believe they would be allowed to testify as to whether he was insane at the time. I think they are both intending to go one step further, indicating that he was not insane, but rather the homicide occurred as a intentional, premeditated killing, consistent with his finding and her finding of psychopathy, psychopath. Dr. Burston does actually use psychopath multiple times in his deposition, and that is a direct result of that. There is nothing that would suggest that that has passed Frye before. I've asked numerous times if the state has anything, just as recent as yesterday again, and I've not been provided any information that Frye would, or that using the PCLR and the determination of mental state at the time of offense is accepted in the relevant scientific community.
If I recall the motion to exclude the PCLR, Dr. Burston, who else testified other than Dr. Burston?
Dr. Burston and there was a bunch of research articles admitted as evidence.
Testimony was only Dr. Burston.
Right, that's what I thought.
But the articles were admitted as evidence.
They were?
The articles were, there was an affidavit that the court did not admit as evidence that I did file along with this, but the actual research articles were admitted.
They might have been, because I think I said I read them, so.
They were filed with the motion, Judge. I don't recall them being put in evidence, but I know they were filed with the motion before it was even heard.
You did not put on any experts to establish what you're trying to establish. You're talking about what Dr. Otto testified to in the middle of the trial.
Which is why we're renewing it. Correct, we do not have a burden. The case law is very clear from Ramirez, from the Supreme Court case, through Ramirez, through Chavez, through everything, that the burden is on the proponent. And so, correct, we did not call any witnesses. Dr. Burston's testimony was that it is not used for that, and the evidence that was introduced was not used for that. Dr. Otto has additionally provided testimony now in trial, additionally saying that this is not widely accepted in the scientific community.
If I recall, I have my notes back there, but I don't have them in here. Dr. Burston testified that as part of his findings of antisocial personality disorder, he used the psychopathy checklist, or I think some other expert referred to it as an asset list or something, to corroborate his diagnosis. And there was also mentioned, and I don't remember without looking at my notes, some change in the DSM-5, which suggested that was a course of testing somebody could follow. But I'd have to look at my notes.
And the issue is not whether antisocial personality, I mean, there's a bunch of inferences that have to be made there. So, one, we have to, just because a doctor or an expert uses it, that does not make it admissible. That's what we're saying. His opinion is based on that. It is not pure opinion testimony because he does use the PCLR. And so we are saying that PCLR has not passed the Frye test in hearings regarding mental state at the time of office. Whether he uses it or not, that's not the point. The point is, in order for that testimony to come in front of the jury.
Well, if it's somehow suggested in the DSM-5, and I don't know, that would certainly be a source that he would use to say, you know, I'm going to look at these features, and this is an assessment tool I can use to do that.
So it's the alternative. Yes. It's the alternative. Not the actual DSM, what was accepted into the book. They have an alternative theory.
Something.
Right, they put an alternative theory in, but it didn't make the actual cut into, these are still the diagnoses.
That's what this, Judge.
I'm listening. Let me go get my notes.
I'll give you the transcript.
Oh, okay.
Can I approach the case, Your Honor?
Yes.
This is the one that you told me you had? The Rice case?
Okay. I had highlighted something, so I apologize. Oh, sorry. Okay.
Your Honor, for the record, I have 898 Southern 2nd, 1164 Ortega Mantilla v. State, and 927 Southern 2nd, 146 Curley v. State.
Okay.
So,
What was the second one?
It's the other one I gave you.
I can't find it on the phone.
H-E-R-I-L.
Well,
Okay.
3 minutes ago.
I would suspect this is my weekend reading.
Well, Judge, I'd like to make some
Yeah, go
arguments.
ahead.
So first of all, I would object to the timeliness of this.
I know.
I mean, the defense is talking about unfair prejudice and being biased, and now here they are wanting to argue a Frye hearing in the middle of trial, after the jury is sworn, after they put on all of their witnesses, and after the court ruled pre-trial already that all of this is coming in, and the state went to trial relying on that. So I think that right off the bat, this should be denied for being untimely. Secondly, this is not really a Frye hearing because they're not putting on any evidence. There's no testimony. We don't have the ability to put on testimony for this Frye hearing that we weren't noticed for today, but I would say we don't need to. Under the Ortega case, it's clear that the PCLR is already Frye tested. So that was a Jimmy Rice case. I know Ms. Manuel will argue it's different, but I'm going to explain why that's relevant. The PCLR is Frye tested. The PCLR, Dr. Burston testified, is a test that was developed to determine psychopathy clinically. That's why it was developed, for clinicians to determine if someone suffers from psychopathy. So the PCLR can be used for other purposes. In that particular case, the district court said that the PCLR is Frye tested, and that's a Jimmy Rice case. But what it's Frye tested for is to determine psychopathy. That's the only way that the test can be used, and that's the only way it's being used in this case. No one is saying that this defendant was sane because he's a psychopath. And we went round and round with that in Dr. Burston's hearing, and Ms. Manuel seems to be suggesting that we're using the PCLR to say that he was sane. And we went over and over that with Dr. Burston. He's not doing that. He is saying that he administered the PCLR to measure psychopathy, which is the same reason why it was Frye tested in the case that Your Honor is reading, to determine psychopathy. We are offering that as an alternative explanation to the murder. This is not new science. This is not novel science. Just because they're experts don't want to administer a PCLR doesn't mean that it doesn't apply to this particular case. And I can see why their experts wouldn't rush out and do a PCLR and come back and tell the people that hired them that, by the way, your client's a psychopath. But our experts, when they looked at all the data, they looked at the collateral evidence, they talked to people, that's what they determined, that the defendant is a psychopath, he suffers from psychopathy, and we're offering that as an alternative explanation. They compared his psychopathy to his mental health issues and found that the psychopathy weighs out more heavily in determining why he committed the murder. And I would also argue that that's a pure opinion for both of our experts, for Dr. Burston and Dr. Lazaro, also not subject to Frye. They're giving their opinion that he was sane at the time of the murder, and they're going to offer as part of their opinion that he suffers from psychopathy, and that that is part of why they believe he was sane, the same way that their experts offered pure opinion testimony. Even some did testing, some didn't, but they all offered pure opinion testimony about why, in their opinion, they think he was sane. This is also pure opinion testimony. The PCLR has already been Frye tested, so I don't think the court has to make a finding or has to have a Frye hearing. It was Frye tested to determine psychopathy, and that's all we're using it for, to determine psychopathy. No one is going to take the stand and say that because he's a psychopath, he can't have mental health issues at the same time, that there can't be coexistent mental health issues. No one is going to say that because he's a psychopath that he was therefore sane. They're saying that his psychopathy was the driving force, the reason he committed the murder.
And Judge, just to quickly comment on that.
Some of this, just let me refresh my memory before anyone else says something. I'm rereading the transcript or part of the transcript of his deposition, his testimony in the motion to exclude. When he talks about the DSM-5, he definitely refers, he calls it the alternative model. That mental health professionals are supposed to be considering a specifier for antisocial personality disorder. PCLR is an assessment tool for features that are consistent with some of the features in antisocial personality disorder. Look at the cross-examination. According to Dr. Burston in his cross, he talks about the alternative model. And he says, they tell you to use it freely, so it's really like one's not good and one's not bad. This is not a black and white issue. And he says, psychopathy is not a diagnosis as a personality disorder. It's a specifier for antisocial personality disorder in the DSM-5, whatever it's called, the alternative, which he says, in his opinion, is an update and is providing additional criteria for clinicians to make a diagnosis. And I understand where you're going, and I agree that the literature I read, it was not used for NGRI. As far as I know, no one's ever presented me with anything that would suggest that the PCLR has been used in a diagnosis correlating with antisocial personality disorder for an insanity defense. But Dr. Burston used it as a tool and was able to reference the DSM-5 alternative assessment to support his position on psychopathy features being identified as part of a personality disorder, and he used a test that, in his opinion, could identify these features.
May I make an additional point?
I'm not done yet.
Oh.
I'm looking for the part where he responds to Never using information. Says further on towards the end that he believes that the PCLR can be evidence of certain personality traits or characteristics in my overall clinical picture. I believe it is an appropriate, clinically defensible, and appropriate use of the test. To say that someone scores high on a PCL and is therefore insane or not insane, or to say because someone is a quote-unquote psychopath, there's no way they could be insane, that would be an incorrect use and interpretation. And then he talks about, in his report, he says there's no reference to Jonchuck being a psychopath. I'm not going to change my ruling. Do you want to say something?
I did, Judge.
Go ahead.
Before we even get to, which I am, like that motion was not to have that was a request to have a Frye hearing. Before we even get there, though, we have to look at the legal relevance. So, going to Ramirez in 90.702. If scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in determining a material issue. That's important. So a witness with qualified training, experience, whatever, can offer in the form of opinion. However, that opinion is admissible only if it can be applied to evidence at trial. What Mr. Boland just said in argument, Judge, was that the antisocial personality disorder does not indicate, actually said that being a psychopath does not indicate that Mr. Jonchuck was not mentally ill, and it does, and they are not saying that because he's a psychopath, he was not insane. That makes it not relevant. They are not allowed to call, so first degree murder trial, they don't just get to call an expert to say, we really think this was premeditated. Even after the defense puts on a case and says, there's reasonable doubt, there's no premeditation, they don't get to then call a witness to say, no, but it really is premeditation. Likewise, in an insanity case, they are able to rebut the elements of insanity, the defense of insanity, if the evidence or the information they are seeking to introduce does not make more or less likely whether Mr. Jonchuck suffers from a mental disease, defect, or impairment, or the word
Infirmity.
infirmity. There you go. And if that testimony does not make it more or less likely that, well, one, he has to be suffering from that. So it really only can go to that first element. You don't get to element 2 if there is no mental disease or defect. It is not proper for an expert to just come and say, well, I don't think it's insanity, but I think this. I think it was really premeditated or it was really bad. The issue is, does it meet the legal definition of insanity? And if being a psychopath or being antisocial personality disorder or having antisocial personality disorder does not make more or less likely whether he has a mental disease or defect, then that's the end. We don't even get down to, because the second element is, because of that mental disease or defect, he did this. And so, or he was unable to appreciate the consequences and the wrongfulness. So before we even get to the Frye issue, it still has to meet legal relevancy. It would, and if they're not using the PCLR, like they just said, to say whether he is sane or not, it is not relevant. It is not relevant whether it could have been premeditated because he has, whether it's premeditated or whether he was insane at the time has nothing to do with his personality type. The state has consistently held that they are not introducing they're not arguing any kind of propensity or character evidence, and the court keeps saying that it's not propensity or character evidence, so it's not relevant to whether he was insane at the time. Before we ever even get to the Frye issue, it has to be able to be applied in the evidence at trial and in determining a fact and issue. And so by their own concessions and Dr. Burston's own testimony that it doesn't make it more or less likely that he has a mental illness, and it doesn't say that because he's a psychopath he's not insane, then it has no relevancy. And any minimal relevancy that they could argue with by stacking inference upon inference upon inference is clearly outweighed by the danger of unfair prejudice. The more inferences they have to stack to make it relevant, the less, or the more likely it is that the prejudicial effect is going to outweigh it. In Ramirez, they specifically said, they go on to say that the trustworthy of the expert scientific testimony is especially important because oftentimes the jury will naturally assume that the scientific principles underlying the state's conclusion are valid. And so if he is saying, well, I just think he's a psychopath, and I think that he, well, in depo, he specifically
I'm
said,
not worried about in depo.
well, he says,
there are going to be limits on, I've made my point about psychopath. And so, in Dr. Burston's hearing, he agreed with me. So no one's going to call Jonchuck unless somebody convinces me it's relevant in any way, a psychopath.
Okay.
Because it is very, very prejudicial, and I don't know that it means anything. Features of psychopathy are different than calling somebody a psychopath.
But they still have to mean something. And so if they don't mean anything, then they shouldn't be admitted. Just because they're not as bad as calling somebody a psychopath, we're just going to say they have the characteristics of a psychopath, but they're not a psychopath. If it's not relevant whether they're a psychopath, it's not relevant if they have the characteristics of a psychopath.
Well, no one's going to be saying they have a characteristic of a psychopath either.
Well, Judge, Dr. Burston has previously said that it's what he thinks is going on in his mind at the time. I think that he's incredibly angry, might have had some grandiosity going, might have had a lot of grandiosity going. I think he was incredibly angry and consistent with my opinion that he's a prototypical psychopath. Another term for prototypical psychopath is aggressive narcissist. He's going to do what he wanted to do. Fuck the cop, fuck everybody, shoot me. I don't give a damn. I'm pissed at the world. The world screwed me over the rest of my life.
Okay, hold on a second. The issue I'm determining is whether I'm going to revisit my ruling on whether Dr. Burston can testify that he used the PCLR to determine if Mr. Jonchuck had certain characteristics that are consistent with antisocial personality disorder, which I believe is a mental health diagnosis in the DSM-5. And he based it in part, his use on the new alternative DSM-5, which suggests that you look at specified, I guess, personality characteristics to buttress your opinion of I'm not a psychiatrist, antisocial personality disorder. And that's what he was using it for. And
I just have one more point.
Judge.
yeah, but it has nothing. And I don't care what he said in his deposition.
I'm
making a decision about whether I'm going to change my decision.
I
And
understand.
I'm not going to.
Okay, can I just put one more thing on?
Yeah.
Additionally, the Florida Supreme Court has said that in applying the Frye criteria, general scientific recognition requires the testimony of impartial experts or scientists. It is this independent and impartial proof of general scientific acceptability that provides the necessary Frye foundation. The burden is on the proponent of the evidence to prove the general acceptance of both the underlying scientific principle and the testing procedures used. And so we don't have, the only independent testimony and evidence we have says that the PCLR should not be coming in. They only called Dr. Burston. They said that the Florida Supreme Court has said that is not enough. And so all the literature suggests that it should not be admissible.
Okay. You had that hearing available to you to call any witnesses that you wanted to. You did not do that. It's the middle of the trial. I think the motion for a Frye hearing is untimely, and I think it would be within my discretion whether I decided to have one, but I don't feel I need to have one because I think I made the right ruling. Antisocial personality disorder is a diagnosis, and one could make many diagnoses of Mr. Jonchuck and feel that one mental health disorder was more prominent than another, which would, I think, lend credibility to one's opinion that he was not NGRI if these features are part of this personality disorder. So I think he could testify to that.
So then would it be proper for me to argue to the jury that they can
I'm
find
not
that
even
his...
going there.
Well,
I'm only going to deal with this issue.
but I don't know how, that's what I'm trying to figure out. If I'm not allowed to make the argument, then is
What
it
argument?
relevant? So am I allowed to argue to the jury that you
I
could
don't
find
have
he
to
has
decide that.
antisocial personality disorder and that's what caused him to do it and that's insanity?
I'm not deciding, and I would probably not limit anybody's closing argument unless.
That would be against case law, Judge.
Pardon me?
Our argument would be.
So is there anything else we need to do today?
Well, the only thing, Judge, just put on the record, Patton v. State, 8787 second 368, Florida Supreme Court from 2004. That case certainly suggests that antisocial personality cannot be the basis for insanity, in which case it would make it even less relevant. if nobody is able to make that argument. The court's indicating that that is a mental disease or defect, that is a mental illness.
In the DSM-5.
Okay, so I'm just wanting to make sure though, so that it would be relevant and I would be presumably able to argue
Well,
that.
I'm not going to start, I mean, we could spend days deciding what's going to happen. I don't know. But Dr. Burston is going to be able to testify that he used this test to identify psychopathy, everyone knows the word I'm trying to say, features, to buttress his diagnosis of antisocial personality disorder. He's not going to be able to call Mr. Jonchuck names. There's a lot of things that I'm not going to allow. So if you think those will come up, then we'll deal with it. But I'm not going to preclude him from saying, I gave this test.
You know, I would say based on the cases she decides, Your Honor, she's answered her own question. She can't argue that because he's antisocial, he's insane. She knows the answer to that question. The case is pretty clear on that.
So, okay, anything else we need to do today?
No.
Good. Okay, so we'll reconvene at 11 o'clock on Monday, and Mr. Ellis or Mr. Bowman, if you find a case that suggests I made a wrong ruling, I will certainly be open-minded on the statement. Okay?
Thank you, Judge.
You're welcome. Or for a case, let me know.
I just argued. Is this yours?
Mr. Ellis, do you want this back?
Is this yours?
Can we take this?